So first, let's look at the definition. What is an arbitration agreement? According to the Ancestral Model Law Article 7, an arbitration agreement is an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. It must be mentioned here that Article 7 comes in two options in the model law, offering two versions of what an arbitration agreement is, so that states when adopting the model law can choose one option or the other. So when we look at the Arbitration Act of a country, we will only see one option or the other, but for the purposes of this lecture, I will discuss both to make a comparative analysis. The first part of the definition that is on the screen now is the same in both options, and it includes a few elements that need to be identified. You can see all the elements highlighted, and we will look at each of these elements separately as they define the types of arbitration agreements and their validity conditions. First, with regard to the types of arbitration agreement. The definition says that the agreement must be about disputes which have arisen in the past or which may arise in the future. An additional section of option 1 of the model law Article 7 adds to this by saying that an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. From these two options, we can see that there are two types of arbitration agreements. One for existing disputes, and they are called submission agreements or compromis, to use the French terminology, and one for future disputes. Those are called arbitration clause or clause compromissoire. The first would commonly be a self-standing agreement drafted specifically to serve the purpose of agreeing to arbitrate an existing dispute, while the second would commonly be a dispute resolution clause in a contract designed for a business relationship rather than a dispute. The literature says that the two types of agreement are different, but they don't have to be. They may differ in content, as an agreement for an existing dispute can be more focused, designed to suit the needs and characteristics of a known issue, while a clause drafted for a future dispute is inevitably more speculative, trying to cover all grounds for whatever the needs and characteristics of a potential future dispute may be. An arbitration agreement in a business contract will be more broad in scope, allowing for any and all possible claims to be arbitrated. We'll choose a seat and perhaps an institution based on general advantages of that seat and institution, and will be drafted with the possibility of enforcement of a resulting award in any jurisdiction where the two parties may have assets. Now, a submission agreement drafted when there is already a dispute will be drafted with that dispute in mind, knowing the role of the parties and anticipating potential places of enforcement of the resulting award, knowing the complexity and the value of the dispute to choose the type of arbitration and the number of arbitrators. But when it comes to the validity conditions, they are the same for both types of arbitration agreements. First, in order to determine the validity conditions, we need to identify under what law will that validity be tested. For this, we get assistance from the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards, because the convention forms the basis for the last retrospective check for that validity in over 160 jurisdictions. According to Article 5.1a of the Convention, there are two possible laws that can govern an arbitration agreement. First, based on party autonomy principles, the parties can choose the law to govern the arbitration agreement. Second, if they fail to choose, which is often the case, the relevant law will be the one from the seat of arbitration. This means that an arbitration agreement must satisfy the validity conditions of the arbitration law from the seat of arbitration. Now, presuming that the seat is in a model law country, the validity conditions I will present in this lecture will be based on the model law, as well as the New York Convention. Validity conditions are of two types, those of substance and those of form. Let's start with the substantive validity conditions, as they are reflecting the same definition we already looked at earlier, Article 7 of the Model Law. To this, I added the relevant provisions of the New York Convention to see how the two together form a coherent system reflecting the same requirements. The text highlighted in the same color across the different articles represent the same elements and validity conditions. First, there must be an agreement expressing the consent to arbitrate. Since arbitration is an alternative to litigation, meaning that you can have one or the other, but not both for the same dispute, any agreement to exclude litigation and create arbitral jurisdiction must be clearly expressed. For this agreement to be valid, the parties must have legal capacity to enter into contracts, because, as I said earlier, an arbitration agreement is in fact a contract. A party can be a private individual, an organization, a company, or a state entity, as long as it has legal capacity. And whether it has legal capacity or not is determined by the law governing that party. Next, the agreement must be to arbitrate a dispute, meaning that there must be a genuine disagreement. Arbitration cannot be used to simply sanction a deal or to rubber stamp an illegal money laundering agreement, for example. It is a dispute resolution method, so there must be a real dispute for it to solve. That dispute must be in respect of a defined legal relationship in international commercial arbitration. This condition relates to the rights-based approach arbitration takes, meaning that it solves a dispute based on rights and obligations and evidence presented to prove those rights and obligations, different, for example, from an interest-based facilitated mediation. That defined legal relationship, however, does not necessarily have to be based in contract. Arbitration can, for example, be to decide on delictual liability or on torts claims, as long as those claims are arbitrable. Because, final condition, the issue in dispute must be capable of being arbitrated. This is a substantive arbitrability condition, so that the issues in dispute are not reserved for the exclusive jurisdiction of courts. Now, before moving on, let's elaborate a little bit on that parties element. The fact that arbitration is contract-based means that an arbitration agreement is only binding between the parties to that agreement. We call them the parties or the signatories to the arbitration agreement, and the terminology originates from the written and signed form of arbitration agreements used to take that I will talk about immediately. Everyone else who is not a party to the arbitration agreement is called a third party or a third party non-signatory. Now, in a simple construction, we would have two parties entering into a relationship from which a dispute arises, leading to one claimant and one respondent. Business reality, however, is a lot more complex. Commercial relationships involve a network of parties with different corporate structures that are connected through a series of different contracts, some of which will have arbitration agreements while others won't. And even those that will have such an agreement may include different arbitration clauses. From this, there are a few possible scenarios that can arise when in dispute. First, multiple parties under the same contract and arbitration agreement. Case in which we have a multi-party arbitration, for which most institutional rules provide. The model law does not expressly refer to multi-party arbitration, and the UNCITRAL arbitration rules only mentions them with regard to appointment of arbitrators in case there are more than two parties. But many modern institutional rules elaborate on multi-party arbitration to cater their services for such complex cases. The other scenario is that of several different contracts with different parties, but connected through the issue in dispute. If the different contracts have the same or sufficiently similar arbitration agreements, the cases can be consolidated under the arbitration rules if those rules provide for this possibility. Some institutional rules do. If the different contracts do not have similar arbitration agreements, the consolidation of cases could be ordered by the court. The argument in favor of consolidating cases to bring all parties and all claims within a single arbitration, if the issues are connected, is to avoid concurrent proceedings, possible duplication of the evidentiary process, and potentially conflicting outcomes. So that is consolidation. Now, if additional parties need to be joined in an arbitration and they are a party to the arbitration agreement, many modern arbitration rules provide for a joinder possibility. The problem is when third-party non-signatories need to be joined, who did not consent to the arbitration agreement that is at the basis of that arbitral jurisdiction. For this, there are a few theories that allow for the joinder of non-signatories, but probably the most relied on and also most disputed one in commercial arbitration is the group of companies doctrine, which practically using pierces of the corporate veil brings in the arbitration a non-signatory, which forms a single economic entity with the party that is a signatory to the arbitration agreement. Now, given that an arbitration agreement is only valid between parties and can only create arbitral jurisdiction over those parties, whether one is a party or not will impact on the validity of the arbitration agreement and the arbitral jurisdiction over that person. As for the formal validity conditions, under the model law and the New York Convention, there is only one, but that may or may not be required, and that is for the arbitration agreement to be in writing. Under option 1 of the model law, Article 7, there is an express requirement for the arbitration agreement to be in writing. The same condition is implied by Article 2.1 of the New York Convention, which says that the convention member states shall recognize an agreement in writing. What this written form means is then elaborated to include all sorts of written contracts or communication. The initial list from the New York Convention has since been interpreted broadly to adapt to changed means of communication and technology developments. Similarly, signature is not required in practice anymore. The more recent model law defines written form to allow for any form in which the agreement could be recorded. This could be electronic communication in any form, an exchange of submissions to arbitration not contesting arbitral jurisdiction, or an incorporation by reference to a document containing an arbitral agreement. So there is a written form requirement, but that written form is flexible as long as it records the consent to arbitrate. In option 2 of Article 7, however, there is no formal validity condition mentioned anywhere. There is only the basic definition of the arbitration agreement that exists in option 1 as well, but nothing further. This may raise some pragmatic question as to how exactly will you prove the existence of the details, the existence and the details of a non-written arbitral agreement. But the fact remains, there is no written form required for an arbitral agreement to be valid. So how do you reconcile this with the agreement in writing requirement from the New York Convention that we just looked at before? Does that mean that an award based on a non-written arbitral agreement that was valid at the seat of arbitration because the seat adopted option 2 of the model law will not be recognized in another state under the New York Convention? That the Court of Enforcement applying the convention would find that there was no arbitral jurisdiction because the arbitration agreement was not valid, because it was not in writing? Not exactly. That would defeat the purpose of having the very liberal option 2 in the model law. Luckily, the drafters of the New York Convention were forward-thinking and realized that requirements may change in time, so they designed the convention to not conflict with such developments. They introduced a more favorable rights principle in Article 7, allowing for domestic law to prevail if it sets a more favorable right than the one provided by the convention itself. Based on this, an arbitration act containing the model law option 2 that sets no formal validity conditions for an arbitration agreement will prevail over the agreement in writing requirements set in the New York Convention. just another example of the flexibility and adaptability of the field to changing practices. And with this, I thank you for your attention. I hope this short lecture gave you a comprehensive explanation of international arbitration agreements and their validity requirements. I hope you become as fascinated by this field as I am. Thank you.